Week 4 of the Waukesha Parade Track trial now bringing the end of testimony in the case.
Joining us to discuss today's developments, attorney Craig Messentuno from the Messentuno Coffey and Thomas law firm. And Craig, we're going to start with a moment from today, possibly giving us a preview of what's coming next in this trial.
I'm just going to tell the jury what they need to know. I'm just going to tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're going to be based on whatever I'll base them on.
Two questions for you. One is, we keep seeing these exchanges, heated exchanges. Is the jury in the courtroom listening to that? And the other is, once he does do his closing arguments, can the judge interrupt him if he goes off on tangents that were not properly entered in the record?
Sure. Judge can interrupt closing arguments whether they're being delivered by an attorney or somebody representing themselves if they're going off track or into an area that's barred by one of the judge's rulings, for example. And generally, no, I have to think none of these exchanges are being had in the presence of the jury. Discussions about, rulings that the judge made or discussions about whether the defendant will testify or what the closing argument will encompass, all of that is done outside the presence of the jury.
Now, 6 of the charges are for homicide. The district attorney decided to make those charges intentional instead of reckless, meaning the jury will have to decide that Brooks meant to kill people. Can those charges at this point, can they be modified?
Yes. So there is a jury instruction conference that was held this afternoon after the defense rested and the state rested. And typically that's for each side to say to the judge, here's the instructions I'm requesting based on the evidence that was presented. So if a defense attorney acting on Mr. Brooks' behalf felt that the evidence could support a finding of reckless conduct, which is a lower degree than intentional homicide, that attorney could ask for that instruction. What the interesting thing to see in this case is whether Mr. Brooks has the wherewithal to request those instructions, or even whether the prosecution or judge will raise that issue themselves in order to guarantee or more ensure that a fair trial is being had, almost raising that issue on Mr. Brooks's behalf.
Is there a concern with so many charges that the jury instructions will be so convoluted that jurors might have a hard time, keeping track of what they need to do?
I understand the question because there's so many charges and each contains an instruction. But I think when you look at this case, the jury is going to decide, was this Mr. Brooks on the identification issue? Was this, in fact, him driving? After that, whether people were killed as a result of those actions or endangered as a result of those actions simply becomes kind of a box check, in my opinion. So it may go swifter than we think.
I think it's at some 73 charges, if I'm not mistaken,
Yes.
and also it's quite a lot.
Reading them all will take a long time tomorrow.
All right, Craig, thank you so much for joining us again tonight.
Thank you.